Hi, I'm Alec Fair, and I'm a senior solicitor in the commercial disputes team at Shepherd and Wedderburn. In this second video on the disclosure and recovery of evidence relevant to court proceedings, we will focus on the recovery of documents once a court action has been raised. As I mentioned in our earlier video, in Scotland, there is no general duty to disclose documents relevant to a dispute. Instead, the court rules set out how documents can be recovered from the other party and also from third parties. The process is known as commission and diligence. This may be granted at two stages of procedure. Before the record is closed, i.e. the point at which parties can no longer adjust their written pleadings without having to ask the court for formal permission to amend them, a commission and diligence can be granted to allow a party to make their pleaded case more specific, or to answer a point raised in the other party's pleadings. After the record is closed, it may be granted to allow a party to recover documents which relate to the matters to be decided at proof. Applications for commission and diligence after the record is closed are more common. The party seeking disclosure makes an application accompanied by what is called a specification of documents, setting out the documents which they are looking to recover. The court must approve the specification, and if it is expressed in too wide or vague terms, and without reference to the facts of the case, it will not be granted. The courts will only order documents to be produced if the party seeking disclosure can demonstrate that they are relevant to the claim and support its pleaded case. As with applications for Section 1 orders, the court will not authorise fishing expeditions. There is a fine line between the need for evidence to elaborate an existing and known case and a fishing expedition where one might be hoping to find something that would support a case that without it cannot be made. Accordingly, in practice, a specification of documents produced by one side will probably be negotiated with the other side before the court approves the final version. The court does have discretion as to what documents are relevant and should be recovered, and can differentiate between critical and non-critical parts of that party's case when deciding this. When the court has approved the specification, the party seeking recovery has a choice between two procedures to use to recover them. Firstly, they may use the optional procedure. This involves serving the order on the person believed to hold the documents and requesting that they produce them voluntarily. Specifications will not necessarily refer to a particular document held by a particular person. It may call for the production of all documents showing or tending to show X, Y, and Z. The party thought to be a haver might not therefore be the other party to the action. A haver may wish to claim confidentiality in respect of some or all of the documents that they're asked to produce, in which case these documents must be placed in a confidential envelope and sent to the court. The court's authority will then be required to open the confidential envelope. The question of whether documents may be subject to privilege will also be relevant, and is covered in another video of this series. Alternatively, or if not satisfied that a haver has properly complied with the order served on them under the optional procedure, the party seeking recovery can ask for an open commission, that is, a court hearing presided over by a commissioner, at which havers will be cited to attend. A haver will then be asked if they have any of the documents referred to in the specification and where they are located, and if not, whether they ever did have them and what has happened to them since, including whether they've been destroyed. A haver is entitled to be represented at the commission, and is also entitled to a reasonable fee for their trouble in searching out the documents called for. In the case of solicitors holding documents, their reasonable fee that they are entitled to will not be at their usual rate that they charge clients. It should also be noted that havers can refuse to answer questions or produce a document at a commission on the basis of confidentiality or self-incrimination. Difficulties arise where documents sought to be recovered are not located in Scotland. There are no means of enforcing an order for production of documents out with Scotland, and instead, letters of request would require to be addressed to the appropriate foreign court. This includes the courts in England, Wales, and Northern Ireland. If, however, the documents held out with Scotland are in the hands of one of the parties to the action, the Scottish court will expect them to be produced. Finally, once proceedings have been started, then the court has a residuary power to order parties to produce documents at any stage, where it considers they may be relevant to the case being heard. For more information on the recovery of documents during a court action, please get in touch.